Warning! Kinda Murdery contains adult themes, explicit language, and descriptions of violence. It is not suitable for anyone, and we recommend you stop listening now.
Hello everyone, and welcome to Kinda Murdery, a true crime podcast that's mostly about murder, and always about the strange and compelling stories that arise when the path less traveled twists to darkness, and those who walk its shadows surrender to violence and corruption. I'm your host, Zevin Odelberg. We have a perilous journey ahead, so thank you for lending me your courage and good company. I'd like to start out today's episode, which I am recording on Wednesday, the day before the drop, by saying happy anniversary to my phenomenal, beautiful wife, Margarita. We've been married 11 years now, and marrying her is far and away the smartest thing I've ever done. There's no question about it. So thank you, honey, for putting up with me, and I sure hope you continue to do so. I know I am far from perfect, which is actually a bit of a useful segue today. You see, every human being has weaknesses, right? Every human being sometimes succumbs to them, and every human being makes mistakes. I think that is something that all of us intuitively understand. But some of us may choose vocations, jobs, that don't allow for us to lose the battle with weakness, that cannot admit the flaws in our humanity, because if we lose the battle within ourselves, the battle to do what's right, for some of us, and more to the point, for others because of us, the consequences may simply be too dire to be borne. I bring you one such story today. It's a story entitled, "For a Respected Prosecutor, an Unpardonable Failure." It was written by Joaquin Sapien and first published by ProPublica.org on June 4th, 2014. Sources are in the show notes. Based on the story in this article, I'm calling today's episode Leeper and Fleming, and I'm choosing to share it with you because not only are its twists and turns compelling, but I think it has much to say about compassion and consequence. So, if you're ready, I suggest that you put your personal items underneath the seat in front of you. Stow your carry-on in the overhead compartment. Let go of the worries of the day, but be sure your seatbelt is fastened. There's turbulence expected ahead. Kinda Murderies, Leeper and Fleming starts now. By any acceptable standard today, it goes without saying that wrongfully incarcerated Jonathan Fleming is the rightful mythic hero, the protagonist of the story I'm about to tell. He is the man who rose unbowed from the depths of the abyss, never gave up, and proved himself righteous. And, by those same measures, James Leeper is our villain. But there's another set of, in air quotes, heroic standards, those of ancient Greece and the ancient Greek tragic hero. Those standards are described like so. Aristotle's tragic heroes are flawed individuals who commit without evil intent, at least initially, great wrongs or injuries that ultimately lead to their misfortune. This misfortune is often followed by a tragic realization of the true nature of events that led to the tragic hero's destiny, which means that the hero must still be, at least to some degree, morally grounded. And, while Jonathan Fleming is unquestionably our tragic victim, it becomes again unfortunately true by modern morals, but obviously true according to ancient Greeks, that former Brooklyn prosecutor James Leeper is the tragic hero of this story. Again, please hold the hate mail. I want to be abundantly clear. I am not saying that James Leeper is a hero. I'm saying that he is a flawed individual who committed, perhaps without evil intent, at least at some point, great wrongs and injuries that ultimately led to his own misfortune. And he certainly has been confronted with the true nature of events that led to his destiny, and he was once, if he is not still, by all accounts to some degree morally grounded, and that makes him a nearly textbook Greek tragic hero. And I mean textbook both literally and figuratively. Alright, enough couching and hedging, let's get into it. On the afternoon of July 18, 1990, James Leeper, a newly minted homicide prosecutor in Brooklyn, had to make a challenging closing argument. The man he'd charged with murder had mounted a substantial defense, offering plane tickets and video footage indicating he'd been vacationing at Disney World when a man named Darrell Rush was shot dead in front of a Brooklyn housing project. Leeper acknowledged to the jury that this seemed like a, quote, perfect alibi. Nonetheless, Leeper confronted the defense straight on. Yes, the defendant, a man named Jonathan Fleming, could have been in Florida around the time of the murder, but Fleming had ample opportunity to fly back to New York, kill Rush, and return to his family vacation. Leeper told the jury there were 53 possible airline flights Fleming could have taken to do just that. Leeper's presentation won the day. The jury returned a guilty verdict. Fleming, 27, was sentenced to 25 years to life in prison. It took 24 years, but eventually it became clear that there had been much more to Fleming's alibi defense and that Leeper had failed to disclose it to the jury. The original case file from 1990 contained a time-stamped receipt showing that Fleming had paid an Orlando hotel phone bill just hours before Rush's murder. The file also contained a letter from the Orlando Police Department informing Brooklyn detectives that Fleming had been seen at the hotel around the time of the killing. By law, Leeper was obligated to turn that material over to Fleming's lawyer, but he had disclosed none of it, which is utterly appalling. And thankfully, in April 2014, Fleming was set free, becoming at that time the latest victim of a string of wrongful convictions involving the Brooklyn District Attorney's Office. But Leeper's role in the case packed a distinctive mix of shock and dismay. Interviews in 2014 with an array of current and former Brooklyn prosecutors, his adversaries in the defense bar, and at least one former Brooklyn judge uniformly produced glowing testimonials to Leeper's skill, compassion, and integrity. People, even those with unflattering views of Leeper's longtime boss, former District Attorney Charles J. Hines, and the office he ran, find it close to impossible to accept the fact that Leeper knowingly hid vital evidence in a murder case. He was universally thought of as a model prosecutor, said Dan Saunders, a Queens Deputy Executive Assistant District Attorney who once worked with Leeper in the Brooklyn District Attorney's office. You'll hear that from everybody, Saunders continued. He was a trustworthy and reliable guy, the kind of guy you want to entrust with the difficult work of being a government prosecutor. I hope people say something like that about me one day. An exploration of Leeper's career as a prosecutor in Brooklyn uncovers an amalgam of genuine respect and personal troubles. Interviews with colleagues detail his quick initial rise in the office, but also a long-standing struggle with alcohol. Those interviews with people who worked with Leeper showed that eventually his drinking earned him a demotion in 2012. In the late 80s, James Leeper was a fast-rising prosecutor known for his fairness and loyalty. Decades later, his alleged misconduct in Fleming's case shocked colleagues and adversaries alike. In 1997, there was a case in which Leeper and the Brooklyn District Attorney's Office were accused of withholding evidence that might have established the innocence of a convicted murderer. In 2014, at the time of these various revelations, Leeper, in a telephone interview, refused to comment. He did not respond to further requests to discuss the Fleming case, his career, or any alleged issues with alcohol. In the early 2010s, the reputation of prosecutors in Brooklyn had been battered. In late May 2014, the New York City Department of Investigation issued a scathing report finding that former District Attorney Hines, among other violations, received political advice from a top New York State judge and misused public money to fund his ultimately failed 2013 re-election campaign. In a lawsuit, he'd also been accused of having long overseen an office of rogue prosecutors, where misconduct was condoned, even encouraged. Hines denied the charges in the lawsuit. One of Hines' top lieutenants, Michael Vecchione, had been accused of railroading an innocent man on a murder charge, a claim he vehemently denied. Another senior prosecutor left the office in 2012 after she was accused of having withheld exculpatory evidence in a high-profile rape case that soon was abandoned. By 2014, some 90 murder convictions involving the office were under review, many involving a retired police detective, and any one of which might have held additional trouble for then-current or former prosecutors. But for all the accusations and embarrassments, however, few in the New York legal world could have predicted that James Leeper would be at the center of the most appalling tumult. Until the beginning of May in 2014, Leeper still had a portfolio of cases he was prosecuting. Then, on May 5, 2014, he was due in court to make another closing argument in a murder case. The family of 23-year-old Nikita Grabelski, a passenger in a livery cab who was shot in the head during a botched robbery, was awaiting justice. Leeper had already laid out all the evidence against 21-year-old Michael Magnan, When he was arrested the night of the crime, Magnan had a .380 caliber shell casing in his shoe. The casing matched the bullet lodged in Grabelski's head. A gun found near the crime scene matched both the bullet and the casing, and there was DNA found on the gun that matched the shooter. All that was left for Leeper to do was sum it all up in one final statement to the jury, but he didn't show up. He was nearly 40 miles away in a hospital recovering from a damaging bout with alcohol, according to numerous colleagues. "I've never heard of anything like this happening before," said Martin Goldberg, Magnan's defense attorney, who worked on New York criminal cases for more than 30 years. The Brooklyn District Attorney's Office announced that Leeper had been suspended. The office did not say why and refused to answer any questions about Leeper's career or his role in any possible misconduct. In the case of Jonathan Fleming, the man whose wrongful conviction destroyed James Leeper's career, Taylor Koss, Leeper's former protege in the Brooklyn DA's office, would become the foil whose investigation ultimately brought James Leeper down. Koss joined the Brooklyn District Attorney's Office in September 2001. He was a young, ambitious lawyer, eager to realize his long-held dream of becoming a top prosecutor, one that he said harkened back to his teenage days, watching hours of Law and Order on television. James Leeper was one of Koss's early bosses and mentors. At the time, Leeper was running one of the most active bureaus in the office. Prosecutors in Leeper's bureau handled nearly all criminal prosecutions in some of the most violent areas of Brooklyn, and the unit was known officially as the, quote, red zone, unquote. Koss said he wanted to shine there, and he saw in Leeper a man to impress and learn from. He had a reputation for being a very strong homicide prosecutor, and it was a reputation that he earned, as opposed to others who were thought of as being political appointees, Koss said of Leeper. People respected Jim for being a workhorse who earned his spot. Leeper himself had already been in the Brooklyn office for 14 years by that time, and he, like Koss, had his heart set on being a prosecutor in his first years out of law school, so much so that he applied twice, enduring a rejection by the Brooklyn office's top brass in 1985, according to the office's personnel records. An assistant district attorney plays two vital roles in society, Leeper wrote as part of his second successful application. The position requires one to be an advocate within the criminal justice system, as well as a neutral and objective representative of all the people in the district in which he or she works. In the latter role, one has the responsibility to thoroughly investigate all leads in a case and to approach cases with a non-advocacy or non-adversary perspective. In that sense, one of the ADA's most important duties is to ensure that a defendant's constitutional rights are preserved and protected. The letter moved the district attorney's office, then run by former U.S. Representative Elizabeth Holtzman, to hire Leeper away from private practice. By 1990, with Hines having succeeded Holtzman, Leeper had secured a position as a homicide trial attorney, an impressively advanced assignment for a young man with only 3 years of experience as a prosecutor. By the time Koss was christened as a fledgling prosecutor in 2001, Leeper was head of the Red Zone, and everyone, according to Koss, wanted to work in the Red Zone. It had the coolest people in it, the coolest bosses, said Koss. It was the place to be, and I got it. I got lucky. Koss reported to Leeper for more than a decade, and he, like many others who worked under Leeper, revered the man for his fairness and loyalty. Leeper stuck up for younger prosecutors when they made missteps. He took them aside to school them in the art of persuading a jury. He gave them opportunities to challenge themselves. He had implicit faith in me, and if you earned that trust, he'd never micromanage, Koss said. He believed I could handle myself. He only came to see me do one trial. I had a cooperating witness, and he came to watch me put him on, and after that he never questioned me again. I wanted him to trust me because I wanted to be in his good graces. People wanted him to think you were a good DA. But those who worked with Leeper came to see a troubled side of him too. In interviews, more than half a dozen lawyers who worked in the office at the time said Leeper's drinking became pronounced, and as a result, a problem. In 2012, according to numerous people in the office, Leeper's drinking cost him his title. Personnel records show he was demoted from chief of the Red Zone back to the Homicide Bureau, but the records do not list a specific reason, and the district attorney's office refused to comment on the cause of the demotion. For his part, Koss moved on to his own new job within the office. He became deputy bureau chief of the Conviction Integrity Unit, a small group of assistant district attorneys and investigators tasked with re-examining old convictions that might have been flawed. In his new job, Koss soon found himself in the uncomfortable and unpopular position of reviewing cases handled by prosecutors who'd made their marks years before. He said, however, that he came to feel a sense of gratification in the work, finding evidence that might lead to an innocent person's release, rather than a guilty person's incarceration. Koss's first case wound up widely celebrated. Over a year-long investigation, Koss and his supervisor, John O'Mara, found evidence that an unemployed printer had been wrongly convicted of murdering a beloved Williamsburg rabbi in 1990. Then District Attorney Hines consented to the release of David Ranta following Koss's investigation in March of 2013. "I'm sure people resented me for it, but I didn't really care," Koss said of his unit's work. In June 2013, 3 months after Ranta's release, Koss left the office, but he said he made a critical observation in his last year there, one that would stay with him in the coming months. Murder cases, especially those tried in Brooklyn in the early, bloody 1990s, could be seriously flawed, and so could the prosecutors who handled them. Newly in private practice, Koss came to learn of an imprisoned man named Jonathan Fleming, and shortly afterward he joined Fleming's bid for freedom. Fleming's case was pending before the Conviction Integrity Unit Koss once helped run, and Koss realized quickly what lay ahead. He'd be challenging the work, and perhaps the ethics, of his one-time mentor, James Leeper. Jonathan Fleming did not have an unblemished record or reputation in Brooklyn in the late 1980s, having racked up a number of convictions, including for robbery and weapons possession. But the evidence that Fleming was the man who gunned down Darrell Rush back in 1989, even at the time of trial, was less than overwhelming. One witness, a crack addict, had testified that she'd seen Fleming shoot Rush, but it was ultimately shown that she'd been more than 400 feet from the scene of the shooting, and had not been wearing her glasses at the time. Another witness had been so reluctant to testify that he had to be dragged to the witness stand by a court officer. As a result, Fleming had spent years after his conviction pressing for a re-examination of his case. The crack addict had recanted shortly after the trial. The man who had reluctantly testified turned out to have testified under a false name. New witnesses had emerged saying that another man was the likely shooter. Fleming's efforts, however, got nowhere. Prosecutors dismissed the crackhead's recantation, as well as the reliability of the new witness. Judges routinely denied his motions for a rehearing. Then, in summer of 2013, with the Brooklyn District Attorney's Office under fire for a variety of alleged misconduct, Koss's former colleagues agreed to look into Fleming's claims of innocence. The ex-colleagues unearthed a bombshell. The Fleming case file had been found, and its contents crippled the case against him. There was, among other evidence, the receipt that had been taken off of Fleming's person at the time of his arrest, and it showed he had paid a phone bill at his hotel in Orlando at 9:27 p.m. on August 14, 1989. The murder took place in the Williamsburg section of Brooklyn at approximately 2:15 a.m. Koss recalled the moment he got the word of the discovery made by his old office. "I was instantaneously nauseous, physically sick to my stomach," he said. "You want to believe that these mistakes don't happen," he said. "Then slowly, you come to the realization that these mistakes do happen, and it results in people losing years of their lives." Koss credits the work of the Conviction Integrity Unit, but the District Attorney's Office said nothing about the botched case other than to consent in court to Fleming's release. Had the case file been lost, overlooked, buried in a police file, or not shared with the prosecutors? Was it intentionally withheld by Leeper? James Devereaux was one of the detectives who worked on the Fleming case. At the original trial, Fleming's attorney had asked Devereaux several questions about the phone bill receipt, including whether he recalled telling Fleming he'd make a Xerox copy of it. He testified that he had no recollection of the receipt, but under questioning conceded that it was possible that one existed, and even that he had assured Fleming he would make a copy of it. But the receipt was never entered as evidence in the case. In an interview with ProPublica, Devereaux said he didn't remember the Fleming case, but he was firm about his evidence disclosure practice at the time. "I'm not in a position to try to put blame on anybody, especially when I don't recall the case," Devereaux said. "But when a case goes to trial, you go to the DA's office with your file, and everything goes over to them. The law is certainly clear about the responsibility for gathering and disclosing evidence. Leeper was the person ultimately responsible for discovering it and turning it over. His failure to do so was unpardonable." In 1990, Jonathan Fleming was convicted of a murder that took place in Brooklyn, New York. These newly discovered documents suggested that he was in Florida at the time, supporting his original alibi. James Leeper, the prosecutor who handled the case, never shared the information. Bennett Gresham, a law professor at Pace University and a leading expert on prosecutorial misconduct, wrote a column in 2014 entitled, quote, "don't let the prosecutor off the hook," unquote. In an interview, he said prosecutors will often try to deflect blame for evidence disclosure problems to the police. But, said Gershman, even if we assume it was in the police file and not in the district attorney's file, and the prosecutor had no first-hand knowledge of this thing, once the defense attorney says, "Hey, check this out, this is a major claim of innocence," the prosecutor has the obligation to go back to the police and say, "Do you have this receipt? Did you write a report? Did you ask the hotel if he was there?" It goes to what your obligation is as a prosecutor, Gershman says. Is it to bury your head in the sand? Or is it to follow all possible leads to find out whether this guy is innocent? This wasn't a needle in a haystack. This was something that was right under his nose. In fact, Jonathan Fleming was not even the first time that James Leeper made this mistake, if indeed it was a mistake, and not just a man overly eager to build his reputation in the prosecutorial office of his dreams. Ann Feldman served for 26 years as a judge in Brooklyn, but across those years she only once exercised the power to set a convicted prisoner free. The prisoner was Julio Acevedo, and the prosecutor whose failure factored into his release? None other than James Leeper. In 1989, notably the same year as Fleming's conviction, Judge Feldman had presided over Acevedo's initial murder trial. Acevedo had been charged with fatally shooting a man in a housing project hallway in Brooklyn. At trial, Acevedo claimed that he'd been caught up in an ugly street beef over drugs and had been forced, with his own life threatened, to carry out the deadly shooting. Acevedo's argument made an impression on Feldman, but ultimately failed to persuade the jury. At Acevedo's sentencing, Feldman said she had, quote, "no idea what the real circumstances were," unquote, that led him to kill. "I suspect the truth lies somewhere between what you said and what the district attorney said," Feldman told Acevedo in the court. She then sent him away for 20 years to life. But the case was back before Feldman 8 years later. Something new had come to light. Evidence that Acevedo's account, known legally as a, quote, duress defense, unquote, was genuine. A prosecutor in a subsequent unrelated case had taken testimony from a man who said he was the person who had forced Acevedo to carry out the killing. The man said he had kidnapped Acevedo and ordered him at gunpoint to fire the deadly shots. Leeper was the prosecutor who took the potentially exculpatory statement. Most damning was the fact that this new information was gained in 1992, just 3 years after Acevedo's conviction, but 5 years before his eventual release because it was never turned over to Acevedo. The man's account had surfaced on yet another unrelated Brooklyn case, and Acevedo's lawyers, when they became aware of it, eventually had it brought to the court's attention. Feldman, presented with the new information, didn't waste much time. Acevedo pled guilty to a lesser charge and was released. "I remember feeling that this guy had told a story at his trial that was true, and just feeling very good about letting him out," Feldman said in an interview last month with ProPublica. It remains unclear, to this day, just what James Leeper was thinking. The man who had confessed to forcing Acevedo to kill had also admitted to Leeper a long string of violent crimes. There's no evidence that Leeper was in any way sanctioned. Feldman, in releasing Acevedo, appears to have only dealt with the new evidence and not the question of Leeper's apparent failure. Still, a spokesman for the district attorney's office would, years later, acknowledge that the failure to alert Acevedo to the new evidence was a mistake. The law, after all, requires that information favorable to the defense be turned over by prosecutors as soon as they discover it, even after someone has been convicted. Dan Saunders, who was a senior homicide attorney in Brooklyn at the time, declined to comment on this particular case, but in an interview, he emphasized the importance of sharing such information no matter what the timing, whether a case is pending or the person has already been convicted or even served their sentence. If we get something exculpatory, there's always an obligation to investigate it and turn it over, he said. Judge Feldman said that Leeper never struck her as the kind of aggressive prosecutor so driven to win that he might break the rules to do so. "It seemed to me that he was a very upfront guy," Feldman said. "He was not overly zealous. I didn't feel like he was out there to kill like some of the other prosecutors." In regards to Jonathan Fleming's case, on April 8, 2014, the proceeding before Brooklyn Judge Matthew Diemick was brief, if momentous. Brooklyn Assistant District Attorney Mark Hale, in consenting to Jonathan Fleming's release from prison after 24 years, quickly laid out the rationale. The documentary evidence, and I'm talking specifically about the receipt from the Florida hotel and the interviews with the employees at the hotel, was not available to the defense at trial. It is likely that the result would have been different, and for that reason we ask that the conviction be vacated. Diemek accepted a motion to dismiss Fleming's conviction, and pandemonium ensued in the courtroom. Reporters from every major newspaper and television channel in New York were there to record an overjoyed Fleming celebrating with his family. His story went viral. A Wall Street banker started an internet campaign that raised nearly $50,000 to help Fleming get back on his feet. Donations came in from more than 600 people in at least 14 different countries. But little was said about Leeper. Few news articles even mentioned his name, and he went on prosecuting a full load of cases. Kenneth Thompson was elected as Brooklyn's new DA in 2013, unseating Charles Hines. As we just heard, Fleming was released in April of 2014, and his conviction was rightfully vacated. On June 4th of 2014, the expose that provided the backbone of this episode was published. And 4 days later, the new DA fired 8 holdover members of the Hines regime, and James Leeper was among them. Other than a future DA candidate in New York returning Leeper's $250 campaign donation in 2015, I could find essentially nothing about him or what's become of him since he was let go by the DA's office. He appears to have been extremely mildly active on LinkedIn in the last 8 months, and that's as much as I could come up with. As for Jonathan Fleming, after his release, he sued the city of New York for $162 million for the 24 years of life that he lost, which seems reasonable. He was ultimately awarded $6.2 million, which was then tied up and unavailable to him because of a dispute between his attorneys for some amount of time, but eventually the funds were released and he used them to establish a foundation, and then he was hired by Tyler Perry to work for Tyler Perry's production company in Atlanta. And I know there's some other cool things that have happened for Jonathan Fleming as well. So at least that part of the story, if you can get over the 24 years of incarceration, which, by the way, no one should, and it's amazing that Jonathan Fleming is able to productively channel the massive anger he must have. But if you can get over that, I suppose you could say that Fleming's story has a happy ending. As for Leeper, he should neither be excused nor forgiven. However, his battles with alcoholism and subsequent hospitalization, I think, demonstrate that he was already at the mercy of his demons and likely a very guilty conscience long before public disgrace drummed him from his chosen profession. Here, I'd like to take a moment to thank Nick Taylor from Paris, France, a listener who reached out to share his feelings about Amy Sarin, another listener's story, which aired on Sunday. Nick writes, "Dear Zevin, I just listened to Amy's story on your podcast and I found it amazing and beautifully read. This is such a great idea and I hope you manage to do lots more. The greatest thing about it for us true crime addicts is that it gives us a real original story, but it doesn't have the negativity of a regular true crime story. Like Amy's, stories like these can be wise and stories of self-discovery that end in a good place. Wonderful work, much appreciated. I hope you get more equally good submissions from other listeners. Best wishes from Paris, France, Nick Taylor." Thank you, Nick. I agree. I loved Amy's story, the dark parts, the light parts, everything about it. Everybody, I would love to get more stories from you. In fact, I am in the process of, and it hasn't gone live yet, but I am in the process of setting up a toll-free phone number. It will be 888-MURDERY. That is 888-687-3379, 888-MURDERY. And you'll be able to call that number and leave a message to share your stories if you'd like. And I hope that you would like. Now, it's going to take me a week or two for that number to go live, but it is coming. It'll be 888-MURDERY, and I hope you use it to share your stories because, as I often say, I think by sharing our stories, we all become more human to each other, and we can build compassion and empathy that way, which is certainly something the world and all of us need. Also, I would like to remind you of the free 3-digit lifeline number 988 that you can call to receive immediate counseling for substance use, mental health, or suicidal thoughts. Please do program it into your phone. Call it if you need it, 988. But if you're not in acute crisis and you'd just like to make a connection, don't hesitate to reach out to me, kindamurdery@gmail.com or at kindamurdery on all social media. I'm here, I care, and I would love to connect with you. And soon, not live yet, but soon there will also be the new, free, toll-free number, 888-MURDERY, that you can call to reach out that way as well. And I hope that you do. All right, everybody. I will see you this Sunday, January 15th. Until then, I'm Zevin Odelberg, and this has been Kinda Murdery.